Okay.
Recording in progress.
What? We got some feedback. If everybody will make sure, other than you, Mark, that everyone's muted, that would be fantastic. So, guys, I'm excited today about this class. It's going to be a 2-part series. It's going to be this week, next Wednesday, same time, will be part 2. Mark has, he's actually been my real estate attorney for many years now, many years. And, when it comes to really, honestly, real estate, estate planning and wills, any of that, like he has been my go-to. If anybody asks for recommendations, he's always my go-to. He's been an attorney, and you can correct me here, Mark, if I'm wrong, but 30 plus years. Is that right?
Well, I've been an attorney since 96, so 27.
All right, 27.
I've been working in law offices since 89, so a little longer than that. So
well, all as I know is you're the smartest real estate attorney I know, and the most trusted when it comes to real estate and estate planning. His company, they still do real estate litigations, they do real estate closings, and Mark does a lot on the estates and wills. And so that's what we're going to share today. Few years ago, my husband and I met with him, and we just kind of talked about the differences with estates and wills, and ended up doing an estate. I'm sure he'll touch on this, but I always had the misconception, I don't know if anybody else has, but I always had the misconception that you had to really have a lot of wealth to have an estate, or to do an estate. I always thought it was for the quote unquote really rich people. But in meeting and learning from him, I come to learn that wasn't really the case. So Mark, I'm going to just let you take it over. So we'll go about 45 minutes. We'll have Q&A at the end. If you have any questions that come up as he's talking today, just feel free to put them in the chat. And then we're going to open it like we always do at the end of these, the last 15 minutes or so for Q&A. So Mark, thank you so much for being here. I know your time is extremely valuable, and just appreciate you being willing and open to share all your knowledge with everybody.
well, thank you, Kathy, for all the kind words. And I see from the Zoom that I see that we have people from all over the U.S. on the call.
They are. Yeah.
So I want to be clear that what I'm talking about are general principles. So it may be different in your jurisdiction, because every state has its own set of laws that govern estates and trusts. And so there's some of the things that I'm saying may not apply to your jurisdiction. I work in Tennessee. That's primarily where I work at. And then so just to outline the program that Kathy has asked me to do, today's program is more on what are the different types of estate planning, what are advantages and disadvantages of those. And then what we're going to try to do next week is how, as an agent, do you work with those estates? How do you incorporate that? What are the right questions to ask clients, that kind of thing, because it's important to understand it first, what it is, and then how to use it, because especially as we have changing times, estates are an area of real estate where transfers always occur. It does not matter what the economy is doing, property within estates transfers. And so by being able to help those clients, and once again, as I tell Kathy, she knows that my famous statement is don't give legal advice, but you're trying to point them in the right direction to whoever your trusted advisor is in your jurisdiction. And so you want to be that helpful person that's not giving the advice, because once you give advice, at least in Tennessee, it can become a felony. And then also you can be held liable for legal malpractice. You're held to the same answer that an attorney would get. And so if you give a bad answer, you can be in trouble fast. And so we want to be careful as real estate agents that we don't make ourselves vulnerable to those attacks. And so I'm just here to protect you guys. So anything that I say that may sound like maybe a scary thought or something like that, I'm not trying to scare or terrify or sell fear. But in the lawsuits that we see, most of the time when an agent is being sued or is the defendant in a lawsuit, the actual case that's being filed really has nothing to do with the underlying problem. What happens is if somebody is upset because their roof leaks or their foundation does this or something that was totally outside the agent's control, and then they just find an excuse to sue the agent. And one of those easy ones is giving legal advice without a license. And so that's where we get into those things quickly. But for today, let's talk about the different types of estate planning. And obviously the most common one is the state intestate succession, because everybody has an estate plan, whether you know it or not. The state of Tennessee and your state will provide an estate distribution plan. You can choose to use that plan. That means there's a lot of state and court involvement, and it means it goes to people that the state selects instead of you. And so that is an option. So everybody's given an estate plan in every jurisdiction within the United States. So if you don't like that estate plan, or if you'd like to have a better one, that's when you move on to your own planning with your attorney. Now, within our practice, we tend to do a lot more trust than wills. And here's the reason for it. And this doesn't apply to all jurisdictions, because in Tennessee, a will has no authority until submitted to a probate court and given authority by that court. Okay, so the will is just a document purporting to be a will until the court acknowledges that it's a will. And so in other jurisdictions, for limited purposes, you can record a non-probated will and it has some authority, but just from Tennessee, there is no authority on that. And so as a will, we have to go through the court to get everything administered. That means we also have to go through and notify all the creditors. We have to invite everybody to the party. So really a probate procedure is an invitation to litigation that you have to pay for. And that's just a poor way to go. So the reason we do a lot more trust planning in our practice is because, one, and this is the most common thing people think about, but it's really not the most valuable, is you avoid the probate process, because a trust survives death. And so you can put your assets into the trust. You're the trustee of the most common. And when we say trust right now, for purposes, I'm talking about a revocable living trust. Okay, we do all kinds of trusts that get far more advanced, but that's not what we're talking about today. We're talking about the kind of trust that most every family would need, which is a revocable living trust. We do a lot of irrevocable trust. We do a lot of asset protection trust, but that's a whole different conversation that could take up days of this also. And Kathy's going to tell me if I stray too far. I'm going to get a little text box or something somewhere that lets me know I've exceeded my bounds. And so if I have, just let me know, Kathy. But with the trust, it also helps our client and yourself during disability, because that's actually the harder thing to deal with. Death, like I say, the state of Tennessee has a plan for what happens to your assets at your death, but disability is becoming the much more complicated subject, because our bodies are just surviving longer than our mental capacities right now. And so that's just a fact. And so even if we're not mentally disabled to the point where we have no legal rights to make our own choices, oftentimes there can be a gray area where there's been a decline where it would be wise for someone else to be making those choices. You know, the law still says you can make your choices, but it might be that you're not making the best choices. And so with a trust, you pick the people that are going to make those decisions for you. And a lot of times we'll have like a parent. I've got a client that we're working on today. Matter of fact, I'll just use her as an example. She's in her 90s. And it is time for her to step aside. She is not legally disabled. She's just tired of taking care of everything. And she knows that she has people that she can trust, that are her trustees, that will do a better job than she can do. So today she's going to resign from being the trustee of her trust after she's been the trustee. You know, she's taken care of all her business for the last 90 plus years, but it's time for her to step aside. So she just steps aside. It's a single document. It's not a hard procedure, because without that, you go through conservatorships in which the state you have a total of 3 attorneys. It's very expensive. And the state looks at all of your expenses and will tell you what you can or cannot spend your money on. And so that gets really invasive on a personal level. And so with the trust, the 2 big things is it covers the disability stage of your life really well, if that's where you end up. But it also allows assets to pass at death really well. The will, you'll see a lot of wills that have a testamentary trust in them. I think that's the worst of all worlds, because you have to probate and then administer the trust. And that is probably the most common thing that I see. And with respectfully, attorneys do wills because they know they're going to get a probate for every will that they do. And that's just a fact, because every will, at least in Tennessee, has to be probated. And so the will may be a couple hours less time on the front end, but it's far more expensive on the back end. And so what we tend to recommend is the trust, because you make all decisions. You don't have any tax plus or minus for this type of trust. It's tax neutral. There's no advantage or disadvantage. We get to plan for our disability. We get to plan for our death. But then also something neat about the trust is if we leave it to whomever our people are, whether it's children or friends or partners or whoever we're leaving our things to, we set it up in such a way that their creditors can't force a distribution. Because in a will, if you just give someone money, if I just leave Kathy $100,000 because I really appreciate the friend that she is, her creditor can stand and just take that money. If you do it properly through a trust, it would always be shielded from all of her creditors. So no one could ever take that from Kathy. So it's a great way to build a nest egg. It's a great way to protect, for example, if we have children, we can protect them from spouses. Because, spouse, I know I'm a big fan of marriage, but spouse is a position, not a person. And so those things can change. And so we can protect these assets from the spouses of our beneficiaries. We can protect it from the creditors of the beneficiaries. We can even protect it from the IRS. And so this is something that you can leave to someone else that really has a great advantage in building wealth and kind of maintaining a little safety net for them throughout their life. We give them the right to take all of these things out at a certain age, whatever you think is appropriate. But it has a lot of advantages for that. So that's how we protect those people. Now, I don't know, I'm kind of looking at a lot of empty screens, so I don't have a whole lot of feedback. So for those of you who are brave enough to have your camera on, I appreciate that because it helps me see what we're doing. I appreciate the smiles too. That's always fun. But if we have someone that has a dependent with a special need or a relative or a beneficiary with a special need, we want to do a special type of planning, because the worst thing you can do is leave someone with a disability money just directly, because it's with the best of intentions. You're thinking, oh, this is someone who can't provide for themselves. This is someone who needs some extra help or care. And so a lot of times people will just leave them money. But if you do that, what happens is, because most of those are need-based programs, things like the insurance that they're on, Social Security, disability, whatever those programs are, and if you give them money directly, it removes them from that program. You then have to spend all the money down. And then for about 6 months while they're reapplying, they have no money and no benefits. And it's really, really hard to do. And so with the best of intentions, we had, for example, there was a case that I dealt with where a couple $100,000 was left from an aunt to a disabled niece. And it was awful. We had to disclaim the gift because the medical condition of the niece, you couldn't have private insurance. And so without the ability to have private insurance, you had to depend on these federal insurance programs and state insurance programs. And so what was intended as a really thoughtful and caring gift ended up being a very destructive gift. And so, but if you just put it inside of a supplemental needs trust, they get the benefit of the money and the social benefits. And so a lot of times it's not that the attorney would be telling you who to leave your money to. That's not the business of an attorney. That's the business of the client. What the attorney will do is hopefully tell you how to best leave it to someone, because sometimes we have a beneficiary that has a drug dependency, or maybe they just have poor relationships where they tend to be dominated by the people in their lives, or maybe they have a lot of creditor problems, or maybe they're just not healthy and they have a lot of medical bills that could result in a medical bankruptcy. And so these are all things that we want to consider. So it's not, don't take anything that I'm saying today and go draft your estate plan. It's very fact specific. We want whoever you're talking to needs to know about your family, and you need to be open and honest with them, because one, you have attorney-client privilege, and two, you're not going to tell them anything they haven't heard hundreds of times. I mean, I have heard every variation of what a family is defined as, or who's done what, or things that people have, and that's just an open discussion. So you need to be honest with your attorney and tell them all the dark secrets and everything that you think might be an embarrassment, but the attorney cannot protect you if you fail to do that. So we're having another conference next door. So if you hear clapping, I don't have a clap track going or anything like that. So they're doing that outside my office right now. So I apologize if there's any disruption there, but we want to make a plan that helps the client accomplish their goals, because an attorney doesn't make decisions. An attorney provides advice and gives you qualifications. And so if you're dealing with an attorney where they're making decisions for you, that might not be a healthy relationship, because you as the client in this case, or your client, all the decisions to come from that source. An attorney's just saying, well, I think what I'm hearing is you're trying to help this person. Here's what I think the best way is to help. We need a supplemental needs trust. We need to make sure they never have access. We need to have limitation on withdrawal rights, whatever we need to do. And so you have the trust, that's your primary transfer of assets. That's what you put it into. And like I say, once again, there's no tax plus or minus to that. It's tax neutral. And then the other things that you want to have is a good power of attorney that connects to that trust. And that's where you want to be careful, because you don't want to have different forms within your estate plan that have been pulled from different sources, because you can have internal conflicts within your plan. And anytime you have a conflict, that can equal litigation. So what we're trying to do is make a smooth, coherent, global plan for all of your succession needs, whether it's during your lifetime, whether it's after your death. So we also want to have a durable general power of attorney, and we want to give it we want to list out, it's kind of a long document, because we want to list out the specific powers, because a lot of times when you'll see these really quick ones where it just references all the powers from your jurisdiction, it'll say all powers pursuant to California Code X or Tennessee, 352101 or whatever it is. Those things change. And so we want to make sure that what you want to have happen happens, and you want your attorney to listen for that. That's something that a lot of the estate planning, it's the same, only so many ways to say certain things, and so there is a lot of similarity between estates, but you want to make sure that you're getting your estate the way you want it, with the flavor that you want, because that's what makes it your plan versus just a generic plan. Because I've not met any family yet that's identical. People are similar. They have a lot of similarities, but I've not met a family that's identical. And so you want to try to listen, and I typically try to talk to clients long enough to figure out what those differences are. Not to pry, but as you talk to someone, people tend to open up. So if you can kind of go with your attorney with the idea that I'm telling them everything there is to tell, you're going to get a much better estate plan, because they can just deal with it right off the bat. Because sometimes there's children that people don't know about. Sometimes there's relationships that people don't know about. Sometimes there's business interest. And so this is the time where it all comes clean. The durable power of attorney, that is important for things like insurance benefits, because you'll need that to talk to the insurance company. You'll need it for Social Security. You'll need it for pension plans. You'll also need it for qualified funds such as IRAs or 401ks, because that cannot be placed in the trust without a significant tax disadvantage right now. And so you use the durable general power of attorney to take care of all those instances. You also have a healthcare power of attorney that meets whatever your vision is of your healthcare. We don't tend to like the advanced directives as much. That's my personal preference, because I like to have a thinking, caring mind in that position. I don't want to have some auto choices that are made, because medical technology is continually changing. Things are always being improved. What could right now be a condition that is terminal with no hope, tomorrow is a very treatable condition. So we want to be careful that we don't somehow limit our treatment, because I've dealt with a lot of ER doctors and nurses who've had to actually reverse different healthcare POAs at different times because there was treatment available. It could save the person's life, but they had this advanced directive that said otherwise. And so you just want to be careful. Once again, you put in your preferences. Do I want to be at home? Do I want to be in a skilled nursing care facility? Does it allow for psychiatric treatment? It's whatever you want. And then also there's a lot of religious beliefs that we have. We have a lot of different clients that have very strong religious beliefs, whether it's an Orthodox Jewish or a Latter-day Saint or Seventh-day Adventist. There's certain things that, so you want to make sure that whatever your preferences are indicated on that document. Then you also have a living will, which is that end of life directive. It says that once there is no treatment, once there is no plan for anyone else, that it's okay to let you pass. And that's really a document. That's not for the doctors. People think that's for the doctors. It is not. It's for your family. Because what we deal with a lot is people that have to make that final choice for someone they love. And there's no closure on that issue. You either feel that you kept them too long and made them suffer, or you let them go too early and there could have been a treatment that they could have received. And there's no right answer to that. And no one will ever tell you with any certainty what the right thing to do was. And so by giving that person your instructions, you're giving them a get out of jail free. So with all the things we talk about with money and that this fun, exciting pass on wealth, that's probably the biggest personal gift that I see that's given to people, because they say, I was just carrying out what they told me to do. And so that's, you're not doing it for the doctors, you're doing it for these people, because you put in someone in a really hard position, and they're doing that for you because they care about you. And so make it as easy as you can. And so once we wrap all of those things in, we want to consider there's just different facts. If we have estates that are worth over, I'm using a number of 5.5 million right now, because the state tax exemption, you have a 40% federal tax. Each state can have its own tax on top of that. We do a lot of Tennessee trust because Tennessee does not have an inheritance tax and Tennessee does not have a gift tax. That's why everybody's putting assets in Tennessee, because it's a low tax jurisdiction. And so without those taxes, you want to be aware of what your local state has in the state tax, but there's a federal 40% tax. And so once you exceed currently $11.3 million, you fall into the state tax. And so that's a fundamental question. I don't know where everybody falls in this, but, and I'm not trying to be funny here, but if I wouldn't count on Congress acting right now. They seem to be very good at not acting. I'm not going political, vote for whomever you want to, but we have a lot of conflict there. And so if Congress does not act by 2025, the estate tax exemption will go from 11.7 to roughly, I'm having to use an estimate number, but it's 5.5, because it would be $5 million adjusted for inflation since 2012. So I don't have that calculation in front of me. But and so suddenly it becomes a lot lower. So at $5.5 million per person, that catches a lot more people in that. And so if you need to do that kind of planning, that's where we use products like irrevocable trust, because IRS says if you are no longer the trustee of the assets, you don't manage them directly. There are ways to get those out of your estate and take the exemption now. And so that's a more advanced form of planning. But I want to say that that is one of the crossroads that you have. How much are you worth? And, will you be using it? Is your plan to use it before you die? Is it your plan to give it away before you die? Because there's a unified credit that money can either be given away during your lifetime or at your death. And so a lot of times we take undervalued assets and we're able to save some money there. So you have to decide where do you fit in that? And then we talked about, care, depending on where we are in our life, may have minor children. We may have adult dependents. Every situation is different. And we do, and people may smile when I say this, but we do a lot of pet trust, because people want to make sure that their pets and their companions are taken care of. And that's it's whatever is important to you becomes important to me, or to whichever estate planner you're talking to. And so you just want to make sure that you have provided for whomever you care for. And so with a pet trust, typically, rather than naming a specific pet, and this is just due to life expectancies, not to be harsh, you typically want to say whatever pets you may have at the time of your death, because if you name specific, then that could always result in problems, because you might have another pet that you take on, or you may have lost a pet and added a pet. You don't want to update your plan every time for that. And so it's whatever is important to you. Now, family situations are complicated. And so sometimes we have blended families. We have children from one spouse, we have children from another spouse, we have two life partners that have one has children, one doesn't have children. There's a lot of area for conflict. So anytime we have a blended family like that, we want to do a lot of planning to make sure it's really, really clear who gets what, because our death to be the cause of a lot of frustration for the people we care about. That's what we're trying to avoid. We want them to say, hey, that was great. Thank you for the gift you gave me. Thank you for thinking about me. This is a good thing. You want to kind of leave on a positive note. But the failure to make a clear plan results in frustration for the people that you leave behind, and can also destroy their own relationships. Because a lot of times you want the people that you left behind to have good relationships among themselves. And so by making a good plan, like all of our trusts say, if anyone argues, they get nothing. So that really cuts down on the argument quite a bit. That's just how we choose to do it. And so that's with the however your family or group is structured, or you individually are structured, you just want to make sure that your plan reflects that. Looking through just a couple other notes that I have here, implementing the plan. This is what, so let's say that you've done the trust. Kathy, am I doing okay on time? Are we?
Yeah, you're good.
Okay, I figure about 10 minutes and then we'll open it up to questions.
Yeah, that'd be perfect.
Okay. And so as you implement a plan like this, what I see all the time is people have gone to an attorney and they've spent a lot of money on a trust, and it's just a great trust. It's drafted wonderful, but they have failed to fund their trust. I see it all the time. And that's why we try, at least from our office, to make sure that our clients have moved their assets over to these trusts that they created. We do a pour over will just in case they don't move something over. But once again, that puts it back into the probate arena, which we're trying to avoid. One of the things we're trying to avoid with a trust in the first place. And so typically you would take, and once again, I'll leave this to your particular planner because there are different answers, but your primary residence oftentimes would go to your trust, your vehicles would go to your trust, your bank accounts. Retirement plans, typically spouse is first beneficiary and trust is second beneficiary. Life insurance would go to the trust. Whatever, anything that has a title needs to be titled in the name of the trust, typically, unless there's a tax disadvantage for doing so. And then sometimes we look for a way to work around on that. And so that's the big thing that I see is people have taken the time to do a trust, they have paid for a trust, and then they haven't funded that trust. And that's not a critical failure, but it is aggravating to the heirs because it pushes everybody right back in that probate position. Or if we have a disability, it's really unfortunate because it pushes us sometimes into a conservator position where we could have avoided that had the assets just been placed into the trust. And then just another note, you can have a great trust, but it's also to communicate your plan to the people that you feel need to be communicated with, because your attorney is not by law allowed to tell anyone else what your plan is. I can't talk about work I've done for one client with another client. I can leave names out and use them as examples when I'm teaching, but I can't talk about anyone's estate without their permission. And so I would recommend that you tell people why you did what you did, because, especially if it's if we're leaving someone out. Because you have the right, other spouses have certain rights, at least in Tennessee and California and different jurisdictions, depending on the law in your jurisdiction. But a spouse has special rights, but everybody else you can leave in or leave out of your trust. That's your business. You can include anybody you want to within that. And so as you're having those thoughts, it can be a good idea to tell people why you did what you did. And maybe it's not important to you, but I've seen a lot of conflict where people are not suing over the money. They're suing for the love or respect of a parent. And there's no way to win that case. That's not something I can give them. I can help them, receive money or have a different distribution, but they're not going to get the approval of their parents. So what they're trying to do really is that if they win that case, they've tied all their emotions into it. So they're also winning back that parent or person's respect or love. And so you don't want to put anybody in that situation. So communicate your plan. It may be, we've had children where situations where one child was extremely wealthy on their own. The other child was a very successful person, but they were a teacher. And so that just didn't pay, the same scale. They were very successful as a teacher. They had great reward for that. They had great accolades for that. And so the child that had a lot of economic success just said, don't write me in anywhere. I don't need any money. Give it all to this person. And so that's where we just want to, there's not a right or wrong answer to it, but communicate what you want, because a lot of people will spend a lot of time worrying over assets that the beneficiaries do not care about. And it happens all the time. Like whatever is special to you, you may have this. I'm just making something up. Like this, the state spoon collection. How about that? We'll use a state spoon collection. You've spent your entire life traveling around the U.S. in your RV picking out state spoons, and they mean everything to you, and you're just tore up because you only have one collection, so you can only leave it to one person because you don't want to break it up. You may well find that nobody else cares about that. And so I would recommend talking to the beneficiaries, because they just may not care, and you're spending a lot of time and money planning for something that no one else cares about. And so, they may not want this house or that house. They may not want the, I always, timeshares, I'm not speaking good or bad, but they're the bane of my existence. And so I'm not, do what you want to with the timeshare, but I'd pick out the person you hate the most and leave them the timeshare. But that's just my opinion. But those are hard to deal with on the estate planning, because all of a sudden we can have a lot of bills or a lot of things that could come from that. And so that it depends on the share itself. So you also want to get the HIPAA release, the healthcare power of attorney, the living will. You want to get that to your doctor and your healthcare providers, because a lot of times, like my doctor has a portal, where I log in, I check my whatever tests they're giving me and appointments and stuff. And I can also upload documents to that portal. Okay. And so by uploading those documents in an emergency situation, a lot of times the hospital can figure out who your primary care physician is through their database. And then those documents become available. And then it's, I think, a good idea, and this is up to you. This is your own privacy, whatever you're comfortable with, but probably the person that you've appointed as your healthcare power of attorney, it's a good idea for them to have either a digital or paper copy of the living will, the HIPAA release, and also the healthcare power of attorney. Because when those things come up, it's an emergency situation. It is something has gone wrong, because you can't make your healthcare choices. Serious healthcare choices are needing to be made, and so you want to make sure as best you can that you protect your own healthcare, because if it takes 5 hours to locate that may be too late for a meaningful decision at that point. So I would make sure that that's well documented with your healthcare provider. And so that's an easy thing to do now. Like I say, most of them have a portal. You just upload it. Distribution of documents. In Tennessee, the originals matter, because if you cannot present the original, it's presumed that you revoked all your documents. And so with the revocation of documents, that means that the whole plan is set aside. And so we recommend that those things go in a safe deposit box at a bank, or in a good sizable fire safe, just to keep them safe. And people need to know where they are. You need to be able to say, whoever your successor trustee and the executor is, they need to know where these documents are. And so, and things change, places of residence change, the jurisdictions change, assets change. And so you always want to keep up to date. And I know I've just got a couple more minutes, Kathy, but you always want to look, kind of dust off your plan, whenever you've had a major life change, or every 5 years or so, and just say, does this still fit? Because it may be that you've appointed someone who's no longer able to perform those functions. You may have assets that you've dealt with that are not there. And it's good to go ahead and remove that, because otherwise people are searching for these assets. If you say you leave the condo in Miami to this nephew, well, people are looking for that. You're going to spend a lot of time trying to find this condo in Miami that you may have sold 10 years ago. And so just, it's good to always update those things. And then just as a practical matter, wherever you keep your trust at, this is not a legal requirement. Once again, we're just trying to help out those people that are helping you out. Is, when you do your taxes every year, you might print out a statement from all of your accounts, credit cards, accounts, mortgages, whatever you have, and put that with your estate plan. Because that way, if something happens, the people that you've appointed can instantly say, okay, we have the Bank of America account, we have the Wells Fargo account, we've got a mortgage with this lender, we've got 2 credit cards over here, we have this investment account. And that can save days and days of work and frustration. Because once again, we've asked someone to do a complicated job and we want to make it as easy as we can. And then every year when you do your taxes, just take the old set out, put it through the shredder and put a new set in, and so that is a low tech way to make the job really easy. And it also helps a lot because sometimes people think they know your financial situation, but don't know the reality of it. So they may think that mom or dad has $10 million over in this bank, but that money was spent 5 years ago. And so if the executor says, no, there is no account, then suddenly there's a lot of anger, there's a lot of resentment, there's a lot of mistrust going on. And so by putting that statement in every year, you can say, well, no, Wells Fargo, it's got, $187 in it. It doesn't have $10 million because we bought the condo here with it. We invested it over here in this investment, or we just spent it on our lifestyle because we just didn't want our kids to have it. We just wanted to spend it all. And that's okay too. That's a plan too. So Kathy, that kind of brings me to the end of what I was going to talk about. I guess at this point, we'll open it up to questions. And then next week, we'll try to put this into a place where it's more framed of how do we take these things and help walk a client through them from a real estate agent's perspective. Because by putting things in the trust, it makes property much easier to sell upon death. It makes it easy to sell upon disability. We don't have to have authorities or approval of anyone else to do so. And so, we'll kind of say, here are the questions to ask. A lot of times we'll find that there are actually multiple estates that have to be, we have a client who was in the office. My paralegal was meeting with them right now to get them to sign some documents that we had drafted, where there's roughly, I think, $25 million worth of real estate. And it goes back to a probate from 1993 that should have happened then, and it never happened. And so we're having to probate multiple estates and multiple generations to clear title. So sometimes it can take a minute to get a property where it's ready to list, because really the people that are signing may not have that authority to even sign agreements with you. And that's where you want to be careful, because as an agent, if you step into that, you can have a problem because you've listed someone else's property without their consent. And so you want to be careful for that, because I don't know about but here in Tennessee, that's a bad thing to do if you list someone else's property. So Kathy, I'll just
one question that I have, and kind of thinking about this as you're going through it, is what happens if people will just say that an estate was set up, but all of the assets weren't put in there, and so the trustee doesn't know about it. Maybe the family doesn't even know, using, would you say, a bank account, for example, or an investment account, something like that. And for some reason it was left out, forgotten, what have you. What happens once that whole estate is settled and finalized? If that appears itself later, like what happens in that situation?
It depends. There's some de minimis authority that's left to the executor. So if it's a relatively small account, there's some de minimis rules, but otherwise you have to reopen the estate.
Oh, okay.
So that's why you want to be careful. And sometimes you can even pull a credit report on the decedent. You can have an asset search. But that's what it really helps, Kathy, in that case, if we have kind of a personal financial statement that we update every year and just put in there, because that way the trustee knows what's in there, because the fear is always the unknown. Have I left something out? Because once you close it, it's just as expensive and time consuming to reopen it, as it was the first time through. And it's super aggravating on all the people involved.
Yeah.
So we want to be as clear as we can. Now, sometimes there's assets that we don't know about because there's an inheritance that may not have been resolved. Someone may have left you something that wasn't in your estate and you couldn't do anything with it, but that gets resolved after your death. And so we have to kind of be aware of those things. So it's a good idea that if you're expecting an inheritance from someone, from some source, you might even make a note of that to your trustee.
Yeah. We spend so much time working and accruing and trying to set ourselves up for retirement and all. And, and we're trying to, leave legacies, some of us, all these things. And, you know, what I've come to learn a few years ago, just in conversations with Mark, and it's like, you know, we spend all our lives getting, you know, accruing and accumulating, but then we don't really have a plan for it at the back end, which is why I think this topic is so important. Because what Mark started with is, you know, if you don't have a plan, you have a plan. The state just has to plan for you. And, you know, it's, do you want the state to decide what's happening to all your stuff? Or do you want to dictate, you know, after, you know, working hard your whole life to, you know, to accrue that? So Christy has a question. It says, regarding single people purchasing a home, either divorced or never married, if they have a friend living with them and the owner passes, does the friend have any right to the property?
But to answer the question, it depends on the nature of the relationship. In some states, well, and this is not a romantic word, this is just the legal word. If it's a romantic relationship, it's a paramour. In some states, you can have a common law marriage that's created because of a romantic relationship. Tennessee does not allow that. And so I'll answer from the Tennessee perspective that person has no rights whatsoever other than as a month-to-month tenant of some kind. There's some kind of tenancy created because they didn't enter the property unlawfully, you know, so they're not a squatter. They were invited to the property. So a lot of times with a trust, like let's say we had just a trusted friend, a non-romantic relationship. Kathy and I are just friends, and she's just living with me because that worked out, you know, for her to do. I would put in my trust, I would say, Kathy has the right to occupy that house for 2 years after my death. That way, you know, Kathy's just not being shoved out on the street, and it gives her some time to take care of that. Did that help answer the question, Christy? So, and so we want to provide, once again, it doesn't have to be a total gift. It could be a you know, a lease period for a certain amount of time. It's not all or nothing. And so that's what we want to provide for whoever the people are that are important in our lives or that depend on us. We want to give them a good resolution, because otherwise they get kicked out and it's terrible.
Yeah. And then Tamara says, how do you prepare for the revocable living trust prior to meeting with an attorney? And what is the cost, and how long does the process take?
Okay, well, a good way to prepare is to kind of work on that personal financial statement. You don't have to have it, but a good list of assets, because it's not just what you have, it's how it's owned. You know, is it in qualified funds? Is it in real estate? Is it, you know, how do we own our assets? And so that's really helpful to the attorney, because it lets us know right away whether we have to do estate tax planning or not. And so that's a big question to ask. A trust can cost you anything. It's just a really wide range. I can only tell you what we charge. My rate is $4.75 per hour. And for most people with kind of regular situations, it's a 5.5 to 6.5 hour process, top to bottom. That I can tell you that. I meet clients that have trusts that are almost identical to ours that have paid 20 or 30,000 for it. Same base, does the same thing. And so there's a wide range. There's no limit on what an attorney can charge. But what you're really looking for with an attorney is someone who, one, listens to what you're saying, listens to your story, and also has the knowledge to provide good answers, because it's not, the document set is part of it, but really it's making it your document set, because LegalZoom for me is a great source of business because it gets done wrong. And so I get paid 20 to 30 times what they would have paid me on the front end to straighten it out after their death. And I hate those situations. I really don't like it, because what I'm thinking in my mind is it would have been so easy for you to avoid this. And that's just that's not my nature. I don't like to strive on, succeed on people's doom and gloom. And so I hate to see it when somebody just clicked the box. I don't even know how you do it, but they clicked the box. Like we had one case where they clicked the box that said descendants instead of children. So instead of leaving all their assets to their children, they left it to 38 individuals, 18 of which were minors. They had to have court-appointed guardians, and it cost them about $250,000 in legal fees by the time they were done. So I think probably the estate plan would have been much cheaper and efficient, and also took about 3.5 years to resolve. So.
So that again, that was one of the questions that I was going to ask is, what do you think about these wills online? And I think you just gave an exact
Well, and I'm not
example
here
of
to
that.
critique anyone, Kathy. It's one of those things where I could walk into a surgery suite we have Vanderbilt University here in the Nashville area. I could walk into a surgery suite and all of the right tools and all the right equipment's there, but I don't know when to use it or the proper way to
Yeah.
do it. And so that's kind of the problem that happens. Or if there's more options, like I may be in the surgery suite for this, and if I were a doctor, I'd say, no, this is a better procedure over here. We need to be in that surgery suite.
Yeah.
And that's kind of where I say, but I'm not here to critique anyone else's work or anyone else's plan, but I like to have people I like to work with people who listen to my story. So.
One of the things when we met with you a few years back and did our trust, the one thing that stood out to me is, or I guess the one thing I didn't realize, and you kind of touched on it today, is, to do a trust on the front end, it's more money. You're paying more money on the front end. But here in Tennessee, and I know you just said it's different in every state, but here in Tennessee, if we just did a will and it has to be probated and you've got attorneys, involved for probation or probating, and all, it really ends up costing more money on the back end, and usually isn't as well planned and thought out doing a will versus the estate. You're not able, my understanding was that you're not able to dictate everything exactly the same. But I think for me, one of the big pictures is like, okay, we could spend $3,000-4,000 here on the front end, but probably save a whole lot of money for our heirs on the back end, several $1,000s having to go through the court, to probate a will if we had gone that route.
Yeah, here in our jurisdiction, it could be different everywhere. Even for a non-contested, nobody's really fighting hard on things. Everybody's just doing the kind of minimal process to get through the courts. It's usually 10 legal hours per probate. Yeah. That's if everything goes right, because you still have to go to court. You still have to meet with everyone. You still have to send out all the letters. You still have to deal with all the creditors. It just takes a minute to do it. And that's without anybody fighting. It goes up from there if somebody starts disagreeing, because we have another case been going on for 2 years because people are fighting over literally trash. It is smelly, old, non-valuable bags of trash, that you would typically, if you saw them in your garage, you would put it in a dumpster or put it in a trash can. But there's one heir that's choosing to fight, and that's what happens.
I know you can tell all kinds of horror stories that you've come across.
Yeah, and I don't mean to do that, but we finally.
We need to hear some of those, because that's when it really makes it real. But
well, I did help on that one. I did ship all the trash to the other attorney and let him hold it in his office for a while. We certainly got resolution. We're getting more resolution now on the trash.
On the trash, that's something.
It was thinking up one of our offices pretty good, but we have to by law hold on to it. We can't just we can't throw things away. That's the job of the executor or the trustee.
Wow.
So
Keith has a question that said, in the case of parents of special needs, should the parents set up their trust and then get the special need person a special need trust within the parents' trust?
It depends on the family structure, Kathy, and it depends on if we have enough assets, because one problem, and I don't want to get too deep in the woods on that, because that's a really serious situation, is you can actually also overfund a special needs trust, because a special needs trust is not supposed to be used for the thing like food and housing in general and things like that, things that are the necessities of life. It's for the extra stuff. And so sometimes families with the best of intentions can put too much money into a special needs trust. And so sometimes there's some other options to plan, but it depends on whether you have very trusted people around you or not. And that just depends on, it's just fact specific, because sometimes we can have some other things that can have some aid that are kind of off to the side and not really labeled as benefiting the person, but there's somebody out there that's kind of an angel that acts as a parent, acts as a parent would. And so that's just something we have to look very specifically on. So I'm not trying to dodge the question. I'm saying that just really depends, because sometimes with families, when you have a child with a special need, it gets really hard because sometimes you have resentment within the family from other children. Sometimes the other children rally around that. And it's not a good or bad situation. There's just really tough situations out in life. And people have had to deal with a whole lot. And so it's just something we have to just take an honest look at, at the facts within that family. So I don't want to be hurtful when I say those things, but there's just, it's a lifetime commitment to care for someone with a special need. And so we want to make sure we get the right people that have the same level of care that we as parents have, or friends have for that. So we would just have to look at other options, but it depends on who the people are around them and what is the nature of their relationship.
So, so we've got about 8 minutes left. I've got a couple other questions, but I want to open it up. Does anybody else have any questions specifically that they want to ask? You can just come off mute and just ask if you'd like. Anybody have any?
I have a quick question. This is Sherry Flory. Mark, so in getting started, I haven't done anything like this before. It's kind of been on my mind. How do you recommend, finding the proper attorney to do this for you? If you have any suggestions, or do you network in other states? I'm in Minnesota.
Okay. My only connection currently to Minnesota is I have purchased a Gaga pit from Minnesota. So a Gaga ball pit. So I don't have a lot of connection to Minnesota. So I apologize for that. But one, I would start with your friends and family to see who has done a good job, and not just the problem is people don't really know how to evaluate their estate plans, but you want to deal with someone that's got facts and situations similar to yours or needs that are similar to yours. And sometimes, like the question earlier, a lot of times with the supplemental needs trust, we can talk to families that have a similar need in that. But otherwise, I mean, I can always, I'm happy to look up online and see attorneys with certain credentials, but I don't, for example, have anyone in Minnesota that I've used, but not necessarily. I think kind of word of mouth is kind of my favorite way to go, because that's people who are happy with the service that they've received.
Sure.
And
so what are the credentials, Mark? Maybe what are a couple of the credentials, and then and what is maybe a question or two? Like if she's going to interview attorneys, what's a question or two to, because I feel like you don't know they're good until after the fact, till the estate's, being settled, right? Then you find out, okay, like that was all done not very well. And so what's a question or two that you would recommend that they ask of an attorney? And then what credentials, one or two credentials would you be looking for when you're looking for an attorney?
Sure. Well, let me go to the credential first, Sherry, is you want to look for someone who doesn't practice in too many areas like we do. I deal with assets. So that's why real estate, estates, and businesses all kind of fall in that, planning that my clients need. And I have specific attorneys that work in different areas of those, more so than I do. But that you don't want someone who's doing criminal cases and divorce cases and bankruptcies and here's a will. That's probably not someone who's focused on changes. I'm not critiquing that, but sometimes you have kind of the general practitioner that just whatever you need, they can do. Well, that's probably not the person you need,
Right.
You want somebody who at least knows. And then I would talk about, what their opinion is between wills and trusts, because a lot of times when you're talking to someone about, they want to just do a will because they have a will form. They've already drafted what they're going to give you. You see what I mean? Like if they're just kind of a general practice attorney, sort of have a will on their desk and they just change the names and here you go, thanks for coming in. And so, if they just say that the trust, oh, you don't need that because of this. I mean, there is a place for a will, but the advantage of the trust are just so great it's not just a little bit, we're not just saving a little or making a lot, it's just that much bigger. And so you at least want someone who's telling you don't need a trust, who understands the trust. Does that make sense? Because a lot of
Sure.
times
Yep.
you'll get advice that they just say you don't need that because they just don't understand it and can't do it, And so
Okay,
that's kind of a big difference that I would kind of start on and just kind of see what they recommend. Just what is their position on that? And if they can just kind of easily just flows off, like I don't have a prepared talk, obviously. So I apologize for rambling a little bit, but
Oh,
this
you're great.
this kind of thing that I can just talk on all day long, whatever you guys
Sure.
want to talk about. And it doesn't, I'm happy to do so. And so you want somebody that's probably comfortable with those topics, and it's kind of just
Sure.
able to rattle them off, and it's just no big deal.
That makes perfect sense. Thanks.
So Michelle said, Mark, do you have or know where there's a cheat sheet maybe of various documents suggested, like the POA? You mentioned several different documents like the health, the health I don't remember the right words, but several documents that need to go within the trust. Is there a cheat sheet of like what those forms and, make sure you at
I'm
least
not aware of a cheat sheet for those, but I'm happy to give the list of what I think, kind of forms a basic estate. If anyone want to take some notes.
Okay, why don't you just spout those off? And then for everybody that's on here, if you're especially with the XP, this is recorded and will be in our Freedom team. So you can go back and catch the end if you don't get them all down. We've got a couple of minutes, but yeah, if you wouldn't mind just running through the list of all the different things within the trust that you feel like need to be covered, the different documents.
Okay, and once again, this is general, so everybody, gets specific advice on it, but you start with the
Yeah.
trust. You do a pour over will in case there's any assets that weren't put into the trust, that would put them into the trust at your death. You do a durable general power of attorney. You do a healthcare power of attorney.
Okay, hold on one second.
I'm sorry.
Let him write those couple of things down. So the pour over, the general durable power of attorney.
And the trust itself.
Yeah, and of course the trust itself. Okay,
And then a healthcare power of attorney. And I like the living will over the advanced directive. That's my personal opinion because of all the changes that can come up. So I like a living will. I do a separate HIPAA release because even though the healthcare power of attorney says that the HIPAA provisions are in force, regardless of whether you have ability or disability, that can sometimes slow down treatment. So I do a separate HIPAA release for HIPAA information so we can get the info to make the choice right away, because we want to make informed choices, not just choices. And so then you want to do a certification of trust, which is a summary of the trust itself. I think that's kind of those are the general documents, Kathy, to at least get you started on it. There's other documents that are transfer documents and things like that. I think there's a question maybe from
Mark,
Kathy.
could you repeat that last one again, please?
Was it the HIPAA release or the
Oh, right after that.
living will?
no,
I don't know.
beyond that.
It was the certification.
Certification. I'm sorry, certification of trust. Certification.
Okay, thank you. Thank you.
And the certification, that's a couple page summary of the trust itself. And that allows you to give that document to banks or investment companies or whoever you're dealing with, but you don't have to share all the internal workings of your trust, because once again, sometimes we have dealt with information that although you've shared it with the attorney, we've addressed it, we just don't want it public. We don't want to hurt anyone. We're not here to hurt someone. And so the certification it's also called like a privacy affidavit in some jurisdictions, because that gives the institution all the data they need, but none of the information they don't need. And so that's why I like that whatever your jurisdiction is, sometimes it's a trustee affidavit, sometimes it's a privacy affidavit. Tennessee, it's a certification of trust.
Awesome. Any final questions for today? Like I said, we're going to come back next week. He's going to do a part 2, and That one will be more around how you talk to your clients. Again, he started off saying, we're not attorneys. We don't want to give legal advice of any kind, but we want to be able to have some conversations with our clients. Again, we're selling, most people's biggest assets. And I would suspect most people want to protect their asset and they want to be able to dictate what's happened, happens to it, to their home and all their other assets, when they pass on. So Mark is going to share with us, as realtors, the kind of conversations that we can have and should have with our clients on that. But any final questions? No. Okay, Mark, thank you so much for sharing all your wisdom, and not actually just one small fraction of all your wisdom you shared, but
You're very kind. Kathy's very kind to me. So you can believe maybe about 1% of what she's saying, but we do
No,
help
you're the
people
best.
out, and I appreciate her. And whoever you work with, like Sherry, you were asking me, like Minnesota, it should be someone you're comfortable with. You want to be comfortable with this person because they're going to guide. They're going to be the ones that are going to draft the documents that take care of you when you can't take care of yourself.
Do you do any states outside of Tennessee, Mark? I put your contact in there for anyone here that's in Tennessee and wants to have a conversation with him. I put your phone number and email. But do you do any other states surrounding the area?
I don't. I just good or bad, I just stay busy with all I can handle here in
Yeah.
Tennessee. But I do have a lot of clients from out of state that create Tennessee Trust, because Tennessee is one of 12 jurisdictions that has some really good trust law, and that's why a lot of assets tend to move here. And so, for example, I'm doing a trust right now. There's a large rancher down in Texas. And so I'm working with an attorney down there to do I'm gonna have them do the pour over will and the durable power of attorney, but I'm doing the trust here because of some, there's just some advantages.
So that's something good to talk about next week, Mark, like for all, we've got agents from all over the place here, but maybe put that, if you wouldn't mind, in your notes. That why would, as realtors, why would somebody maybe want to have their client give you a call? We'll say, for example, of, doing a trust in Tennessee, even when they're not in Tennessee. So let's talk about that next week, because like you said, there's some advantages. So maybe we'll touch on that a little bit more next week, because as a realtor, if I'm outside of Tennessee and I can save my clients potentially some money, or the estate some money at the end, I would at least want to know about it, and so we can touch on that a little bit next week when we're talking.
Well, I don't want to be critical of anyone's state, but if you're in a state that's the budget is always in trouble, taxes will only go up. So anything you can move outside the jurisdiction of that state is usually helpful from an estate perspective.
See, and that's good to know, because myself anyway, I didn't even know you could move it outside of the,
Well, you have to be careful. It gets a little complicated, but there
Yeah.
are things we can do to make it in a different domicile
Yeah.
jurisdiction. And so,
well, that's good to know, and we'll talk
Thanks,
more
Richard.
about that next week a little bit. So thank you again, Mark. Thanks, everybody. This recording will be up later today in the Freedom Team if you want to go back and grab anything you may have missed. But come back next week and we'll continue part 2. Y'all
Thank
have
you.
a
This is
fantastic
great.
day.
Thank you very much.
Bye,
Thank you.
everybody.
Bye.
Thanks,
Bye-bye.
Mark. Bye-bye.